Yes. On that basis, my lord, then, we urge you to consider giving conservatory orders to be able to allow yourself look at those issues. Well, I think I have very few minutes, my lord.
You have 5 minutes.
Thank you. Then what is the prejudice of not granting conservatory orders, my lord?
Yes.
My lord, if conservatory orders are not granted or confirmed, it means that the provisions of Article 181 kicks in that the Deputy Governor of Meru County is sworn in as the substantive governor of Meru County, capable of discharging and exercising all the mandates, powers, and privileges that comes with the position of a governor. He could fire all the CECs. He could rearrange the government. He could disrupt service delivery.
Yes.
So if then the court was to later find that indeed this impeachment was a sham,
yes,
there would be no way of rectifying that situation, because we will have to go through a new process of now removing that governor, and I do not think there is any mechanism in law to do that.
I've paused your time so that you can ask this question. Does the High Court have the power, if the petition was to be successful, to nullify the appointment of a governor who came in under Article 181, put the petitioner back in office, and address these eventualities that you outlined?
Well, that's quite debatable, because the only way...
Hold on, I have to write. After and reverse is quite debatable. Yes, proceed.
There is only one known procedure of removing a governor from office. Whatever process that brought the governor to office, by going back to Article 181 and Section 33 of the County Government Act.
Yes.
So the High Court has not been granted very express powers to remove one governor and replace with another.
Yes.
And even if it had, my lord, and we are arguing it doesn't, what about all the other actions taken by this governor? Is the court capable of also offering a remedy to those actions? That's why the court must look at the balance of convenience. Where does it lie? Is it having the governor who is in place continuing to serve with minimal disruption? And if later then the petition is found to be unmerited, pronounce itself, and then allow the deputy to take over?
Your time is back on.
Yes, I submit, my lord, that the balance of convenience tilts in favor of the petition in this case. The inconvenience, the prejudice is too much, not just to the petitioner, but to the people of Meru.
Yes.
And we are not asking you to install a new governor in place. We are asking you to allow the situation remain as it is.
Yes.
I submit that it is actually in public good and public interest for the governor to be allowed to continue serving, offering services until such a time when the court pronounced itself on the question at hand. My lord, I believe that I have covered most of the areas.
Yes.
I reserve the rest for our rejoinder.
You have 2 minutes to go, so I'll add that 2 minutes.
Yes.
So you rejoin the...
We just wish to point out to the court.
Secretary, a little louder, please.
Yes, we'd like to point out to the court, Your Lordship,
Yes.
that we filed our complaint about the application of the petition. The same is sworn by Mr. Jeremiah again on 28 August 2024.
Yes.
And equally, Your Lordship, we filed our written submissions. The same are dated the 11th of September 2024.
Yes.
We wish to wholly rely on these documents, Your Lordship. Your Lordship will notice that in my submission, I made a brief background on the impeachment, just how it came to be from the County Assembly to the Senate.
Yes.
But Your Lordship, to open my submissions, I would like to briefly address the question of what, where, when, why, and who with regard to the impeachment process, Your Lordship. I will not focus much on what, where, when, Your Lordship, but I will examine who impeaches, Your Lordship.
Yes.
Your Lordship, with regard to the subject of the impeachment, it is easy to state that is the governor, Your Lordship.
Yes.
But with regard to who impeaches, Your Lordship, it is the County Assembly and the Senate, Your Lordship.
Yes.
Your Lordship, under Article 177(1), a County Assembly is elected office. People of Meru County.
Yes.
Further, Your Lordship, under Article 90,
Yes.
Your Lordship, under Article 1(2), the Constitution states the people may exercise their sovereign right either directly or through their representatives. In this regard, Your Lordship, I would like this court to perhaps take my view that when an impeachment is done, Your Lordship, it is by the people, Your Lordship. It is not the senators, it is not the MCAs, Your Lordship. It is the people who are actually exercising this right, Your Lordship.
Yes.
Your Lordship, this position is supported by the case by your sister, which is Constitutional Petition number 4 of 2024, which is Nyamira. The case is Purity Mora Kirera versus the Senate and the Speaker of the Senate, Your Lordship.
Nyamira, is the petition number?
It is number 4 of 2024, Your Lordship. It is Nyamira.
Yes, party.
The parties is Purity Mora Kirera versus the Senate and the Speaker of the Senate, Your Lordship. Your Lordship, this case can be found at pages 157 to 204 of our list and bundle. Yes.
Was an appeal lodged against this decision?
Your Lordship, this case, this was just the interim phase, the ruling phase. The case was still ongoing.
Was there an appeal for that ruling against that ruling?
Not to my knowledge, Your Lordship. Not to my knowledge.
No appeal against ruling?
Yes, in fact, Your Lordship, lighting of the submissions in the main petition, the matter is ongoing, Your Lordship. Scheduled for.
Yes.
Just to go back on that, Your Lordship, your sister took the view that I implore this court to adopt,
Yes.
which is that when an impeachment occurs, Your Lordship, it is not just the senators, it is not just the MCAs, Your Lordship, it is the people of Meru.
Yes.
Now, Your Lordship, with regard to how impeachment is done, well, that's a bit straightforward. We can examine Article 181 and Section 33 of the County Governments Act, Your Lordship. But then I will also go to why impeachment is done, Your Lordship.
Yes.
Your Lordship, I will just quickly make reference to the case by Martin Nyaga Wambora and 3 others. And Your Lordship, further, the case of Sonko versus County Assembly of Nairobi City and 11 others.
Yes.
111 into brackets E008 of 2022. I have made reference to it in my submissions, Your Lordship.
Yes.
And Your Lordship, of impeachment, or rather it considers what impeachment, the why impeachment, Your Lordship. And the court says that the impeachment is a constitutional and political process, Your Lordship.
Yes.
And the Supreme Court further, in the case that I've noted, Your Lordship says that the design of impeachment is to achieve accountability, political governance, and personal responsibility. And the same is not just aimed at
The design of impeachment is to achieve?
accountability, Your Lordship,
Yes.
political governance, and personal responsibility. The court further states that the same, which is impeachment, is not, the aim is not necessarily to find criminal responsibility, Your Lordship.
Yes.
So, Your Lordship, even when examining this matter, we are not looking at it from the lenses of criminal culpability of the governor, Your Lordship. It is accountability. It is political governance. It is personal responsibility about the governor, Your Lordship. With this background, Your Lordship, I turn to now the grounds in the application. Your Lordship, first I'll start with whether there's a prima facie case.
Yes.
Your Lordship, you've been told about the various omissions by the Senate. You've been told that there was an existing court order, Your Lordship.
Yes.
Your Lordship, I would like to submit that indeed, Your Lordship, and you'll check from the documents, that there was no court order stopping the impeachment, Your Lordship.
Yes.
Your Lordship, if you look at my application, dated the 3rd of September, which is to set aside the orders,
Yes.
Your Lordship, I have annexed a copy of the notice of motion that resulted into the ruling by Justice Kassan, Your Lordship. Your Lordship, from that application, Your Lordship.
Just a moment, let me find it. Of course, your time.
Yes.
I'm there.
Yes, Your Lordship. I will refer you to page 39.
Yes.
Yes, Your Lordship. I believe our application, Your Lordship, to set aside.
Yes.
Yes, Your Lordship, if you look at the application that resulted into those orders, Your Lordship,
Yes.
it makes reference at paragraph D, Your Lordship, to the impugned motion of impeachment dated 15th July 2024, Your Lordship. Your Lordship, if you look at the documents that have been submitted by the Senate, including the document
Motion of?
of 15th July 2024, Your Lordship.
Yes.
Your Lordship, if you look at our documents supplied that initiated the motion at the Assembly, the motion is dated 31st July 2024, Your Lordship. So, Your Lordship, it can't be that there were blanket orders stopping the impeachment, which is what the petitioner would like you to believe. And further, Your Lordship, just to buttress that the orders herein were meant for that specific motion, Your Lordship. In fact, they captioned it in their documents. They had the option of leaving it blanket, Your Lordship, for any possible impeachment. They didn't do that. They were specific to 15th July 2024. And the motion that resulted into the impeachment is the one dated 31st July, Your Lordship. And so, Your Lordship, I submit there were no court orders halting this process, both at the County Assembly and at the Senate, Your Lordship.
I'll call your time to ask you a question. Mr. Kutuma used the phrase mischief. That he seems to be saying, and they've said it in the submissions, that the county assembly, once served with the court order, realized that it was targeted at a specific date motion, came up with another motion on the very same reasons. Should the court uphold this?
Your Lordship, my answer to that briefly is that, one, I do not hold forth for the assembly. So perhaps, Your Lordship, if the petitioner had sued the assembly, we would have gotten their view about the proceedings before the assembly, Your Lordship. But to the extent of the Senate, Your Lordship, and in fact, Your Lordship, that begs the question, one, condemn the county assembly without hearing them as well?
Your time is back on.
All right. Under Article 260 of the Constitutional Forum versus the Attorney General and 3 others, Your Lordship, in this case, this by the county assembly,
yes,
seeking payment for the remainder of term, a reduction in their time in office by declaration of a general election, Your Lordship. That was it.
Yes.
Your Lordship, while dismissing this argument, the Supreme Court quoted a case, and I've made reference to it in my submissions, which is Attorney General X versus Joachim, which is a case from the Supreme Court,
yes,
which one, Your Lordship, states that the legislature may, within limits of the Constitution, provide of incumbents from office, Your Lordship. But most importantly, Your Lordship, this decision stated that an elected office is a public trust, Your Lordship, and not the private domain of an office holder. The office holder holds the office for the benefit of his constituents, or her constituents in this case.
yes.
Your Lordship, this decision just reiterates the point where I started with, that the ultimate power belongs to the people. There cannot be a private right and a private need for holding office, Your Lordship. And Your Lordship, from this premise, my submission is that there cannot be a prima facie case in this instance, because we are speaking about a public office, Your Lordship. A public office. The rest of the allegations, Your Lordship, have been answered, so I'll just quickly skim through, including the issue, Your Lordship, about the alleged debt that the Gazette notice was of a different date, Your Lordship. We have comprehensively answered that in the. So, Your Lordship, I'll move on to whether the applicant would suffer prejudice in the order if the order sought are not granted. Again, Your Lordship, I reiterate that decision. This is a public office. This is not a personal office, Your Lordship. So what prejudice would you suffer? In any case, if the petition succeeds, Your Lordship, then the court would simply reinstate the applicant, Your Lordship. As it stands, Your Lordship, a decision... Oh, okay.
So I've paused your time.
Okay.
Your colleague, Mr. Mukima, took a different view. You heard what he said.
Yes.
To his mind, it's not as simple as reinstatement. There may be prejudice to the people of Meru County and others in the intervening period. Please address that.
Your Lordship, thank you for that question. And immediately I would go to the decision from Wajir County impeachment, Your Lordship.
Yes.
This to just demonstrate, Your Lordship, how powerful a court order is. Your Lordship, through a court order, all actions can be undone. And by way of example, Your Lordship, just to show how powerful a court order is, Your Lordship, the acting DIG at that time, Mr. Masengele, came to court because of a court order, Your Lordship. That is how powerful it is.
Your time is back on.
So, Your Lordship, just on issue B, as I submitted, the office is a public trust, Your Lordship, and no prejudice can be claimed in this instance, Your Lordship, because it is the people who have exercised their right to the impeachment, Your Lordship. Now, Your Lordship, whether the petition will be rendered nugatory, I submit that it will not be rendered nugatory, Your Lordship, because of the reasons I've just explained, and I'll make reference to the case of Wajir, Your Lordship, where an impeachment process was Your Lordship, I have another interest on another limb rather on public interest, Your Lordship, and I still refer to the decision from Nyamira, the Nyamira case, I'll call it, and to persuade Your Lordship that public interest favors the orderly organization of state, constitutional and state organs, Your Lordship. So in this case,
Interest favors the orderly
organization of constitutional and state organs, Your Lordship. In this regard, Your Lordship, what is at stake is a decision by the Senate, which has the mandate to impeach, Your Lordship, or to validate the impeachment rather.
Yes.
That decision has been undertaken, Your Lordship.
Yes.
This decision was undertaken by the people, Your Lordship. This is one arm of government, Your Lordship, which is the legislature. And so, Your Lordship, until the full hearing of this matter, the governor stands impeached. And Your Lordship, even as we speak about status quo, what is the status quo? The status quo is that the governor has been impeached. That decision has not been set aside.
Yes.
So, Your Lordship, we submit that the decision of the Senate can only be invalidated or otherwise through a substantive hearing of this petition.
Yes.
Not at an interlocutory stage, Your Lordship. Your Lordship, I'll make reference to the case of, there's a civil application in paragraph 36 of my submissions, but I won't read into it, Your Lordship. I want to go to the next issue of whether the applicant has approached the court with clean hands, Your Lordship. Because clean hands is vital to the to conservatory orders, which is an equitable remedy, Your Lordship. Your Lordship, you were told of a court order. I believe we have since dispelled those rumors. There was no court order, Your Lordship.
Yes.
And so, Your Lordship, on this, David is sworn that there exist court orders, Your Lordship. It deceived this court. This limb alone is enough to demonstrate that the applicant has also approached the court with clean hands, Your Lordship. Your Lordship, I'll finalize with whether this court should set aside. Your Lordship, far from what you have been told, that the issue of misjoinder, Your Lordship, or non-joinder for that matter, Your Lordship, we have also spoken to the issue where our states that there were existing court orders, Your Lordship. But perhaps for context's sake, Your Lordship, I will refer you to a decision by Matatu Owners Association versus National Council of Administration of Justice and another. That is paragraph 43 of our submissions, which speaks to when a court can set aside ex parte orders issued, Your Lordship. And one of the grounds therein is misrepresentation of facts or non-disclosure of material facts, Your Lordship. Your Lordship, the wrongful joinder or non-joinder of the Senate is just one of the issues, Your Lordship. Your Lordship, you are told there is an existing court order. There is none. And secondly, Your Lordship, you've been told that they correctly sued the Speaker of the Senate. You've been given a plethora of authorities about that, Your Lordship. But Your Lordship, under Article 122(2)(a), the Speaker has no vote in matters before the House.
Yes.
Your Lordship, how then would you have a situation where you sue the Speaker, Your Lordship? In fact, if I've listened to my seniors, my colleagues, the entire time they've talked about the Senate, the decision of the Senate, the resolution of the Senate, Your Lordship. They have not spoken about the Speaker.
Yes.
I believe, strongly believe, Your Lordship, and it is our submission, that the proper parties in this matter is the Senate, Your Lordship. The Senate undertakes this exercise. The Speaker is an ex-official member, Your Lordship. And finally, Your Lordship, I still make reference at paragraph 50 of our submissions that if the court finds that indeed it is the case, and I submit it is the case, then the court can actually discharge those orders, Your Lordship.
Yes.
And in any case, Your Lordship, just going back to the issue of the Senate, Your Lordship, if you look at the orders that were granted by this court, Your Lordship, and Your Lordship, perhaps allow me to just read the order.
Yes.
Your Lordship, order number 2 states that pending the inter-parties hearing and determination of the application dated that a conservatory order be and is hereby issued staying the furtherance or implementation of the resolution of the Senate, Your Lordship. The Senate is not a party to these proceedings, Your Lordship. How can it be that parties benefit or seek to benefit from conservatory orders wherein those parties have not been sued, Your Lordship? I submit that cannot be the case, Your Lordship.
Yes.
And in any event, Your Lordship, as submitted in paragraph 54, order number 3, which was granted, restraining the Speaker from publishing or causing to be published in the Gazette notice, was overtaken by events, Your Lordship. They say that the Gazette notice was predetermined, Your Lordship. We have at length given explanations and reasons as to why that is not the position, Your Lordship.
In brief, why isn't that the position?
Your Lordship, when the Senate undertakes its business in accordance with the order paper, there is the order for the day, Your Lordship. The order for the day was the impeachment, Your Lordship.
Yes.
And Your Lordship will notice at paragraph 46 of our replying affidavit, we have at length explained what happens when there is a division, Your Lordship. Division simply means voting, Your Lordship, in the House.
Yes.
When the division happens, Your Lordship, it allows the Senate or the House to continue with proceedings until that division is complete. And Your Lordship, in that regard, the proceedings of that day are still continuing until that vote on the division is taken, Your Lordship. This is in the Senate standing orders, Your Lordship. Order 34-6, Your Lordship.
Order?
34-6 of the Senate standing orders, Your Lordship. We have at length explained that from paragraph 46 all the way downwards, Your Lordship. And I believe that...
The petitioner's position...
Yes.
I've paused your time. The petitioner's position is that the Gazette notice shows that this was a predetermined process where the outcome was notified to the general public before the vote actually took place. Is that factually correct?
No, Your Lordship, that is not factually correct because of the explanation I have just given.
Part of the reason we open court, you can see that I am logged in.
Yes.
It's for the benefit of persons who are following this proceeding.
Yes.
So in as much as I've read your various responses,
Okay.
please articulate that so that they are able to understand.
Okay. So, Your Lordship, I have given Your Lordship the standing orders, the relevant standing order, which is 34.6.
Yes.
Now, Your Lordship, upon the close of submissions by the parties,
Yes.
the following events transpired, Your Lordship.
Upon the close of submissions
By the parties.
before the Senate.
Before the Senate, yes, Your Lordship. The following events transpired. Make reference to paragraph 47 of our response to the petition and the application.
Yes.
Your Lordship, one, the Senate Majority Leader moved a motion
Yes.
for the impeachment, Your Lordship.
Yes.
Secondly, Your Lordship, and just to summarize, also moved a motion pursuant to standing order number 111, sorry,
Yes.
that the debate for the proposed removal be limited, Your Lordship. These are from the standing orders, Your Lordship.
Yes.
And Your Lordship, once that was complete, a division was proposed, Your Lordship. All this happened in the day gazetted for the impeachment, Your Lordship. Now, Your Lordship, once the division was proposed, then under the standing orders, Your Lordship, division has to be complete before the business of the day is concluded, Your Lordship. And that is exactly what happened.
Okay, your time is back.
Yes. So, Your Lordship, it is only after the division and the taking of the vote that the process was concluded, Your Lordship. And in any case, that is why the Gazette notice reads that date, because it is the date when the business was complete, Your Lordship. It does not spill over to the next day, Your Lordship.
Yes.
And so, Your Lordship, I think with that, and barring a clarification from the court, I would beg to rest my submissions on that, Your Lordship.
Still have quite a bit of time, 6 minutes, 42 seconds. You're comfortable?
Yes, I'm comfortable, but I can donate to an interest.
Submissions.
Thank you, Your Lordship.
Mr. Lorry?
Thank you very much, my Lord. On the part of the first interested party,
Yes.
we have filed written submissions dated 2nd October 2024, alongside our list of authorities,
Yes.
also filed and dated on given date, my Lord. We wish to rely wholly on the contents of these submissions and the authorities placed before you, my Lord. My Lord, we will further wish to associate ourselves with the submissions of the petitioner who has just highlighted them before I rose on my feet. Your Lordship, these submissions are in support of the petitioner's application dated 21st August 2024 and in opposition to the application by the respondent dated 3rd September 2024.
Yes.
Lord, in light of saving judicial time, I may not wish to regurgitate what has been said by my learned senior, Mr. Ngora, and also my learned colleague, Mr. Mutuma.
Yes.
Your Lordship, the application by the petitioner was filed after the petitioner, Her Excellency Governor Kawira Mwangaza, underwent an impeachment process, was marred with unconstitutionality, in bad faith, and tainted with procedural impropriety,
Yes.
as will be demonstrated at the full hearing of the instant petition, my Lord.
Yes.
My Lord, the application for the conservatory orders, my lord, was summarized in the case of Wilson, Kaberi and Kunja versus the Magistrates and Judges Vetting Board and another, that is constitutional petition number 154 of 2016 at the High Court in Nairobi. It is authority number 1 in our list of authorities.
Yes.
The principles have been well enlisted in this particular case, and I would just like to summarize that the applicant must demonstrate that they have a prima facie case with a likelihood of success unless the court grants the conservatory orders. There is a real danger that the applicant will suffer prejudice as a result of the violation or threatened violation, and further, if the conservatory orders are not granted, then the petition will be rendered nugatory. From the summary that I have just been able to lay down, the first interested party has laid down the issues for this court to warrant this court's determination in our written submissions. And my lord, the issues are 5 of them, and I will list them. Whether the applicant has established a prima facie case to warrant the issuance of the orders.
Mr. Lawyer,
yes.
I think the counsel for the petitioners sent us those
yes.
While they are different authorities,
yes.
they speak. The principles were long established.
Yes.
So maybe you can skip that to the end.
Yes, my lord, that forms the substratum of my submissions because these principles have been laid out, and I was actually intending to avoid regurgitating the points that have been already laid out. But perhaps, my lord, just to go into the issues without repeating the authorities because they are on record for the judge, for the court, to be able to decipher. My lord, as I delve into the first issue, and as was said by my learned colleague, Mr. Mutuma, on the issue of the prima facie case, my lord,
yes.
It has been stated by the principal.
The challenge that the court has
yes.
is those, you can go all the way back to the 1950s.
Yes.
You can even go beyond that on what is prima facie case.
Yes.
I would be constrained to record something twice.
My lord, is the position of the court then that I just adopt my submissions because these issues and these principles are well laid out? Unless the court is inclined to make me just adopt my submissions, we will be guided by yourself.
I'd want to save the environment by conserving ink, so writing twice may not
yes.
be the best way.
Yes.
What I wish you to highlight
yes.
is more of the why.
Yes.
That the role of an interested party has been well defined
yes.
all the way up to the Supreme Court. Why is the interested party saying that these conservative orders should be confirmed and extended to judgment?
Yes.
That you could use your time on that, please.
Perhaps, my lord, just to give you, although this is not in my written submissions,
yes.
we were constrained to only file written submissions. I didn't file a response, but perhaps just to come to bring to the court up to speed of the functions of the first interested party.
Yes.
They are laid out under section 20.
Yes.
And part of the functions of the first interested party is to consider matters of common interest to the county governments.
Yes.
That is part of the mandate that has been bestowed upon the first interested party.
Yes.
And the impeachment of county governors has been a matter of concern to the first interested party, specifically, my lord, with regards to the issue of the procedure and the process that was followed.
Yes.
My lord, the law that relates to removal of governors from office is laid down under Article 181
Yes.
and also under Section 33 of the County Governments Act, my lord.
Yes.
But my Lord, I wish to submit that part of the processes that have been adopted both by the assemblies and the senates have been through jurisprudence of these courts. So the first interested party takes a lot of interest with the impeachment process to be able to follow through, albeit in a very neutral process, my Lord, but just to be able to see through that the procedures that have been laid out, the procedures with regards to fair hearing, fair administrative action, the rights of elected, specifically governors, to hold office under the provisions of Article 38 have been laid out, my Lord. That is the specific interest that the first interested party has with regards to this particular process, my Lord. Without, my Lord, that was just a background, without, my Lord, going into the meat of whether a prima facie case has been laid out, my Lord, allow me to skip into that so that I can just canvass the rest without necessarily regurgitating what my learned colleague, Mr. Mutuma, has said. What is the likelihood of the prejudice? That is my second point on my written submissions, which concerns itself with whether there is a likelihood of prejudice if the conservatory orders are not issued, my Lord. The prejudice that the petitioner is likely to suffer, my Lord, pursuant to this impeachment process, in the failure of the conservatory orders, my Lord, there are processes that kick into place. The first process is that, in line with the assumption to office of the Governors Act, the Deputy Governor is then sworn in, my Lord.
Yes.
What are the consequences of the Deputy Governor getting sworn into office, my Lord? And the prejudice that the petitioner will suffer in the unlikely event of the court not granting these conservatory orders, my Lord, automatically there will be a change in the whole executive of the county government, same from in the position of governor. The rest of the members automatically go with the outgoing governor, if so.
Yes.
This leads to a complete shift in the governance of the county, my Lord. There is a likelihood of possible changes in policies. As my Lord, you are aware, the governor, being the head of the county, is the #1 policy holder, my Lord. So there is a likely change in policy. There is a likely change in some of the legislation that then operationalize the policies that have been put into place by the administration.
Yes.
My Lord, there is a constituent that is not presently before you that may not have the audience. Those are the CCs, members of the County Executive Committee. The prejudice that they may suffer, my Lord, once they go out by operation of law, what then happens to some of their obligations, my Lord? Some of them may have running facilities. I don't speak for them, but that is the prejudice that they may be able to suffer, my Lord, if these changes are likely to be occasioned, my Lord.
Yes.
As I finalize on that point, there is no prejudice whatsoever, we submit, in issuance of the conservatory orders, pending the hearing and determination, and we will pray we have an expedited one of the petition that has been filed before you, my Lord.
Yes.
The next point, my Lord, is whether the substratum of the petition will be rendered negative without the conservatory orders being put into place, my lord.
Mr. Kawira, please. Yes.
My lord, as I've stated earlier on, the substratum of this petition may be reduced into an academic exercise if the subject matter, that is the removal, is not preserved pending the hearing and determination of the petition. And as my lord has been stated, there are already tribal issues that have been highlighted by my learned colleague, Mr. Mutuma. Tribal issues with regards to compliance with court orders, my lord.
Yes.
With regards to the fair hearing that was afforded to the governor in the Senate. With regards to a predated gazette notice, according to the petitioner.
Yes.
My lord, we submit that if these conservatory orders are not put in place, which are very critical in preserving the subject matter, pending to the court's determination of the petition, then the governor will suffer undue prejudice, my lord.
Yes.
I do not wish to restate what I've already said with regards to the organizational structures being changed in the county. I wish to save the court's time. My lord, the other issue is whether the granting of these orders is in public interest.
Yes.
My lord, we submit that it is in public interest that these conservatory orders are maintained for continuity of service in the county government of Meru, my lord. My lord, we have seen, yes.
There's a deputy governor in place.
Yes.
How would services be disrupted? Delivery of public services be disrupted by that deputy governor becoming the governor?
My lord, it is not about the person of the deputy governor. As I said, once the governor ceases being governor and a deputy governor assumes office, there is supposed to be legally a change. The county executive committee members who are appointed directly by the governors cease to hold office. These county executive committee members are the ones who are in charge of the departments and dockets, and they supervise the rest of the people below them. So this change,
Is there anything to bar their reappointment?
there is absolutely nothing, but they cease holding office, my lord.
Yes, continue.
Thank you, my lord. My lord, it is in public interest, as I finalize on this point, because the people of Meru exercise their sovereign power by electing the petitioner into office, my lord. My lord, we submit that it is in public interest to maintain the status quo pending the hearing and determination of this instant petition, so as to ensure that the electorate who put their vote to the governor receive services from her administration pending the hearing and determination of the issues that have been raised or canvassed or will be canvassed in the petition. As I said, my lord, this is against the background. Yes, my lord.
Mr. Makere made a point that perhaps the status quo, when we use that phrase status quo, the status quo was that there was an impeachment.
Yes.
By resolution of the Senate. And you have also used the word status quo, the term status quo.
Thank you.
But yourself and your counterpart appear to have different interpretations.
Yes. Yes.
When I issued those orders, what was the status?
My lord, the status pending the issuance of the orders was that the Senate had voted to uphold. The status upon the issuance of the orders, which is the prevailing status up to now, in my own view, my lord, is that there is an order that has stayed that particular upholding by the Senate. That is how I interpret it.
Before my orders?
Yes.
What was the status?
As I said, the status quo before your orders was that the Senate had voted to impeach, to uphold the impeachment, my lord. Yes.
And how was that status, that circumstance, against the public interest?
The public interest is that, as I have said, my lord, the people of Meru exercised their sovereign right to go and elect, and which they did, my lord. And as such, they have a right to receive services from the administration of the person that we elected, my lord.
Okay, move on.
My lord, we have seen in the recent past continuous impeachment attempts by the County Assembly of Meru against the petitioner.
Yes.
And it is in public interest that, my lord, and this is the very first one, my lord, where the Senate voted to uphold, my lord. It is in public interest that the conservatory orders in place remain until such a time that the process that led to the Senate upholding this impeachment process is determined by this court, my lord.
So the public interest is that the issues laid out in the petition should be canvassed substantially.
Yes, as they continue receiving service from the person whom they elected into office, my lord.
Canvassed substantively as the people of Meru continue receive services from the person they elected to office. You have about 2 minutes, 15 seconds.
My lord, I'm just making my winding remarks. My lord, the last issue in my submissions is whether the omission of the Senate from the proceedings render the petition incurably defective. I do not wish to regurgitate, as I said. I rely wholly on what was submitted by my learned senior, Mr. Ngoya, as well as what is in the text of my submissions, because it's a copy and paste, my lord.
Yes.
And as I finalize, I would like to state that even though the impeachment process is a quasi-judicial process, my lord, it is governed by the rule of law, which we are all called upon to uphold.
Yes.
I do not wish to state any further. I wish to rest my submissions there. Thank you very much, my lord.
Thank you. Council, you have 20 minutes.
Good afternoon, my lord.
Good afternoon. And you're the only one who's had the courtesy to wish me a good afternoon.
Yes.
Yes.
My name is Herman, once again. I'll be submitting on behalf of the second interested party, that is Federation of Kenyan Women Lawyers, FIDA.
Yes.
To give a brief background, FIDA made an application to join the proceedings as an interested party on 5th of September 2016.
Please speak a little bit louder.
We could invite my learned friend and give the opportunity.
Please sit near a microphone. Yes, Ms. Maya?
Yes. The second interested party made an application to be joined as an interested party to these proceedings on 5th September 2024. In the hearing conducted on 24th and 25th of September 2024, by consent, it was agreed that the interested party to be allowed to be part of the proceedings. These submissions that I'm here to present, dated on 2nd October 2024, are made in support of the petitioner's application dated 21st August 2024 and in opposition of the respondent's application dated 3rd September 2024. Secondly, I associate with the submissions by the petitioner and the first interested party, and therefore will be very brief so as not to repeat what has already been said. For that reason, I will go straight to the issues that the second interested party put forward for determination in the matter. So the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. Secondly is whether the ex parte conservatory orders issued on 21st August 2024 ought to be reviewed, varied, set aside and or discharged. And third, who bears the cost of this application? To the first issue is whether the petitioner has met the threshold for issuance of conservatory orders. I do not wish to repeat the principles that have been stated by the petitioner's counsel. However, I wish to highlight that conservatory orders are granted on the inherent merit of a case, bearing in mind public interest, the constitutional values, and the proportionate magnitude and priority levels attributed to the relevant case. Further, conservatory orders are issued in exercise of the discretion of a court.
Yes.
The second interested party relied on the case of Gatirao Peter Munya versus Dixon Mwenda Kipinji and two others. That's at 20, the citation is 2014 EKLR for the courts that have made on the conservatory order being public in nature. And therefore, what is more important in this case is that the constitutional edict to be protected and that it be observed by members of the Senate and of the County Assembly elected as representatives of Kenyans, the citizens of Kenya. Therefore, misuse of such powers that the members of the County Assembly and the Senate have should not be allowed by the court. It is on this premise that we implore the court to uphold the conservatory orders and that the same to not be set aside. And to my second issue on the exercise of discretion by the court. My Lord, the court is alive to the social constructs in Kenya, the patriarchy in our societies, and the general dynamics of our society.
Just a moment, Counsel. Did FIDA file an affidavit?
No.
So I think we can just skip the observations about the general nature of our society. Unless they are founded on an affidavit, those we cannot read and rely.
I am guided. Having said that, that is the end of my subject.
You had outlined the third issue. You had outlined the third issue.
I adopt the submissions and pray that the court rely on those in determining the matter of costs.
Thank you, Counsel.
Thank you, Your Lordship. Allow me on behalf of the third interested party to urge you, Your Lordship, while the conservatory orders were not deserved and ought to be discharged. My Lord, we rely on our written submissions dated the 30th of September 2024.
Dated
30th September 2024, and the case laws embedded on those submissions, Your Lordship.
Yes.
My Lord, I'll submit to you on 3 limbs. The first is on public interest. My Lord, the second is on the question of nugatory. And my Lord, lastly, on the balance of convenience. My Lord, my departure point is Article 1 of our Constitution.
Yes.
And which, my Lord, provides that all the sovereign power belongs to the people. And my Lord, under Sub-Article 2, the people are allowed to exercise that sovereign power either directly or through their elected representatives.
Yes.
My Lord, the people of Meru County, through their elected representatives being the members of the County Assembly,
Yes.
elected to impeach their governor.
Yes.
My Lord, the propriety of the procedure which they followed was clear, and I believe it has been well explained by the respondent in this petition. My Lord, public interest, I would want you to be guided on what the Supreme Court has said in petition number 10 and 11 consolidated of 2024. That is the case of Dock Workers Union and Okio Mutata versus KPA and others.
Yes.
And Your Lordship, the Supreme Court was very, very candid that the third ground that a court should consider while granting or denying conservatory orders is the impact of such orders beyond the parties to the case, and should the order be granted or denied, what is the or maintain the conservatory orders, this petition is going to be rendered nugatory. My Lord, we humbly submit that the position of a governor, with all due respect, Your Lordship, is not personal to any individual. It is a constitutional office. The holders of that office are public officers within the meaning of the law.
Yes.
My Lord, no person can cling or individualize the position of a governor. As such, Your Lordship, the law provides for mechanisms of removal of a governor, and that is exactly what has happened in the matter before you, my Lord. My Lord, it is trite, and the court was kind enough to read our mind, which is also in our submissions, that indeed, even if the governor was to be found to have a meritorious petition before you,
Yes.
you have powers to reinstate her to office. My Lord, you have powers to order that she be paid damages. My Lord, again,
you have powers to issue any appropriate orders that will remedy her as a person of the governor. My Lord, as such, Article 182, Sub-Article 2 of the Constitution also provides why there will be no vacuum, because a deputy governor will be able to take office and discharge the functions of a governor. As such, Your Lordship, there is no issue of nugatory or the petitioner or the petition being rendered nugatory before you, because the law has provided safeguards, sufficient safeguards over such a matter.
Yes.
My Lord, if you allow me again, I had my colleagues submit that there is no way of dealing with a deputy governor who presumes office. And my Lord, I would want to refer him to Article 182, Sub-Article 6 of our Constitution,
Yes.
which provides that a deputy governor can as well be removed.
Article 182, Clause 6.
Sub-Article 6,
Yes.
which, my Lord, provides that a deputy governor can as well be removed if he does not act within the Constitution provisions. My Lord, you've also been told that the petition will be rendered nugatory because the county executive committee and the cabinet will be kicked out of the office because the governor has been impeached. My Lord, with all due respect, that position is inaccurate. Those persons are a constitutional office holders elected or nominated or given that power pursuant to legal provisions. In fact, their terms run for 5 years. And my Lord, the mayor, deputy governor, does not mean that those persons will as well go home. My Lord, you've also been urged that in regard to Section 33(8) of the County Government Act, and my Lord, is a humble submission before you that that provision of the law enjoys the presumption of constitutionality. My Lord, in any event, and with all due respect again, the issue of Section 33(8) in Meru, which is still pending and which has not been prosecuted. My Lord, with all due respect, without going into the facts of the matter as an interested party, you are urged that there was an existing court order barring the impeachment process. My Lord, our first question is, was the Senate a party to those proceedings? My Lord, our second question is, if indeed there were proceedings that barred the impeachment process, as the petitioner filed in the contempt application in that court, and my Lord, if they want you to deal with the issues of Section 33(8) of the County Government Act, have they sought a consolidation of the two petitions so that this court is then embodied to deal with that issue? My Lord, with all due respect, we feel that those facts have not been brought before you in the proper way, and you're being enjoined and you're being misled, with all due respect, where there is not material disclosure of the proper facts on the ground, and upon which your Lordship was misled to issue a conservatory order. My Lord, as I end up argument on that point, I wish to remind ourselves that the term of the petitioner as an elected governor is not indefinite. It's only limited to 5 years. The law anticipated that that term can be stopped or curtailed through a legal process. That is what has happened, Your Lordship, and there is nothing illegal about that. As such, the petition before you cannot be said that it will be rendered nugatory when a legal process has taken place. My Lord, allow me to go into the question of balance of convenience.
Yes.
Your Lordship, allow me to pose a question. What would happen if Your Lordship maintains the conservatory orders in this matter and eventually finds that the petition before you is not merited? My Lord, the people of Meru, the voters of Meru, one of whom I represent before you, will continue the suffering they have endured since the governor took office, and they are enduring in the current stalemate in Meru County. And Your Lordship,
apologies, I object to that. A learned colleague, like my other learned colleague, did file an affidavit. The question of people of Meru suffering is a purely factual issue that can only be brought to the attention of this court by an affidavit. I urge that he strongly instructs from submitting such a factual issue without an affidavit, because we want to know the particulars of suffering, or that we deal with them one by one.
Mr. Karimi,
yes, Your Lordship.
please limit yourself to the scope of your submissions.
Thank you, my Lord. I will limit myself. I urge Your Lordship to look at the facts from the parties who have filed affidavits of fact. Thank you. My Lord, on the balance of convenience, I was submitting that in the event that you find that this petition was not merited, and by that time the voters of Meru County will have endured the lack of a proper governor for the county. And that, my Lord, with all due respect,
Mr. Karimi,
yes, my Lord.
Mr. Ngoy has not raised to his feet, but I think you can reword that.
Thank you, my Lord.
That submission.
Thank you, my Lord. Okay. Thank you, my Lord. My Lord, allow me to leave that and move to my second limb of argument, where the balance of convenience, my Lord, we feel that favors the lifting of the conservatory orders.
Yes.
My Lord, we humbly submit that it will have been, with all due respect, unfair to the people of Meru County to have endured a process whereas they could have sworn in their deputy governor and proceeded with the management of the county affairs, while the governor finds justice in the petition before you, without a conservatory order being in place. My Lord, with all due respect, we also want to look in the question of the status quo.
Mr. Karimi,
Yes, Your Lordship.
if I'm to understand that point that you just made, you're saying that there is a balance of convenience where each party, each side gets something. So the voters get a new governor, the petitioner gets to argue their case, and at the end of the process, if the court reverses the decision and the actions that were made, so be it. If not, then no harm is done. Is that what you're saying?
My Lord, we are saying more than that, in the event the court finds that the petition is also merited, it is clothed with sufficient means of remedying the governor. It can order damages, it can order reinstatement, it can issue appropriate orders, Your Lordship, that will assuage the governor.
I'm trying to see how you can frame this without having to fight an affidavit, because you do represent the interested party who is admitted because they have voted. Perhaps it is impossible.
Thank you, Your Lordship. Thank you, Your Lordship. My Lord, I wish to also submit that the question of status quo as escalating from the Senate,
Yes.
and as escalating from the members of the County Assembly of Meru who are not parties in these proceedings,
Yes.
is that their governor stands impeached.
Yes.
My Lord, in my humble view, the balance of convenience tilts in favor of maintaining the status quo that has been adjudicated by at least another arm of government.
Yes.
My Lord, we further urge you that the fact, and if you allow me, this goes to the issue of joinder, which we've also submitted on, the fact that, Your Lordship, the members of the County Assembly were not enjoined in these proceedings, neither was the Senate itself enjoined in these proceedings. We humbly submit that that omission is fatal for the following reason.
Yes.
My Lord, the mover of the motion of impeachment, the owner of the motion of impeachment, is the people of Meru through their elected representatives. With all due respect, Your Lordship, they are the mothers of the motion. My Lord, failing to enjoin them in the proceedings before you, we humbly submit was mischievous, with due respect to my colleagues. And Your Lordship, I wish to distinguish the case that was cited before you. By my colleague, that is the Speaker of National Assembly versus the Center for Rights of Educational and Awareness and 7 others.
Yes.
My Lord, that particular matter before the Court of Appeal did not emanate from impeachment proceedings.
Yes.
My Lord, the role of Senate in impeachment proceedings is unique and peculiar. My Lord, the role of the members of the County Assembly again in the impeachment process is also quite unique.
Yes.
With such a Lordship, the non-joinder of parties in that particular matter, where the court said did not go to the issue, did not affect the fundamental rights of the parties, cannot be the same as a matter involving impeachment of a governor. And with such a Lordship, that matter is not on all fours like the matter before you, and is quite distinguishable. My Lord,
Going through your submissions,
yes, Your Lordship.
and also those of the respondent,
Yes, Your Lordship.
there was quite some ground covered as to prejudice, where essentially this court is being invited to interrogate the constitutionality of parties that are not before this court. You've alluded to it being the Senate and then the County Assembly. Can this court safely give orders at the end, or even at the interlocutory stage, that affect parties that are not before this court?
My Lord, we humbly submit that this court should not issue orders affecting parties who have not had an opportunity to espouse their position before you. Your Lordship, I wish to remind the petitioner, perhaps, that the person they have sued, that is the Speaker, does not even hold a voting right in Senate. So the Speaker is not per se directly the owner of the motion that went on to impeach the governor. The real people who impeached the governor is the Senate and the members of the County Assembly from Meru, whom my client participated in electing. Your Lordship, allow me to also submit on just one issue, the one you asked about mischief, and I think we had submitted a bit on it.
That is your time, but I'll
Thank
give
you.
a bit more.
Thank you, Your Lordship. Thank you for indulging me. Thank you. My Lord, with due respect, the Senate, understanding orders 111, foresaw the mischief that can be perpetuated.
The Senate at standing order?
111
Yes.
foresaw the mischief that can be perpetuated during a motion of impeachment, like the one that emanated the proceedings before you. And as such, Your Lordship, they limited the question of the debate of that motion. And again, in the wisdom of Senate and our constitutional makers, they also gazetted the days and the timelines for debating such motions. Lordship, I'm trying to go around the issue that was raised by the petitioners, that there was communication that came out erroneously without appearing to go into the facts of the issues. And my Lord, we humbly submit that that issue is amply covered by the respondent, and that mischief was cured, and that is why the communication and to come on the 20th of August, because time froze, whether it was midnight or past midnight, time froze until the motion was debated and concluded. Finally, Your Lordship, with all due respect, allow me to associate fully with the submissions made by the respondent before you, and urge Your Lordship to kindly vacate and set aside the conservatory orders that have been in place and that have made the people of Meru continue suffering. My Lord, good afternoon.
Good afternoon to you. I'm glad it's catching up.
Thank you.
Mr. Ngoya, you had indicated 10 minutes in joinder.
Yes.
Having listened to your colleagues, I don't think 10 minutes will be sufficient. Can we try? Let me give you 20.
I appreciate.
But try to keep it under 20.
Thank you so much.
And it is rejoinder.
Thank you.
So direct responses to what
For the 20 minutes, I will use 15 minutes. My learned colleague, Mr. Mutuma, will use 5 minutes. Let me go straight to the point. But let me begin by asserting that it is sound principle in constitutional interpretation that a constitution must be read as a whole. Let me just begin by asserting that as a principle and make the following then statements of rejoinder. It has been said that what is at issue here is the sovereign power of the people of Meru. Let me summarize that as the issue. To that, we respond as follows: that it is true that all sovereign power first belongs to the people of Kenya, with a rider that it shall be exercised only in accordance with this constitution. Only in accordance with this constitution. The petitioner is telling you that this rider has been violated. That's what the petitioner is telling you. This rider has been violated. That this power has been exercised in violation of this constitution.
Yes.
The second issue that has arisen is that the petitioner has no, may I call it, private or proprietary interest in the office of governor. A submission was made to that effect.
Yes.
Again, let me read Article 38, Clause 3, Paragraph C of the Constitution. Article 38, Paragraph 3, Article 38, Clause 3, Paragraph C. It says, every adult citizen has the right, without unreasonable restrictions, to be a candidate for public office or office of a political party of which is a member, and if elected, to hold office. The governor is saying, I have a constitutional entitlement to hold office unless I am constitutionally removed. And he's saying the removal here is unconstitutional. We are making an argument, my lord,
Yes.
whether or not it was or it was not constitutional is a matter for trial in the main petition. But we are saying, in the meantime, let us stop disturbing the status quo. Let us hold the matters as they are. I'll address you on this issue of status quo because it's an issue by my colleagues on the other side shortly.
Yes.
Number 3, again, my learned colleague for the third interested party iterated the issue of joinder of the speaker, and the speaker having no voting at paragraph 57 of the judgment in the case of the Speaker of the National Assembly versus the Center for Rights, Education and Awareness. Where
Paragraph 50.
Paragraph 57. Paradoxically, the argument was precisely the same argument.
it went. I would read it, my lord, without asking you to regurgitate it, just for a full tenor. The appellant, understandably, as we do here, protests that the Speaker has no role in initiating bills and does not even possess a vote in support of or opposition to a bill. And for that reason, he cannot be sued by the failure by Parliament to discharge a constitutional mandate to pass legislation. Same thing here. The Speaker doesn't bring the motion, does not vote on it, and what does the Court of Appeal answer? The Court of Appeal answers, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent for the following reasons. Then from paragraph 58 through 59, reasons are given. Same argument, same principle. My colleague says he wants to distinguish. How? The Court of Appeal is saying, in our view, where it is alleged that the National Assembly or the Senate has violated the Constitution, the Speaker is a proper respondent. The petitioner is saying, in relation to her, the Senate has violated the Constitution. The Court of Appeal is answering, the correct respondent is the Speaker. And let me ask my colleagues the question I've asked other colleagues before. Let's assume they are right. And you are sitting there, my lord, with a Court of Appeal in front, the decision in front of you as well. What do they want you to do? What do they possibly want you to do? I think sometimes, as Jesus Christ said, it is written that they shall not put me to temptation or something like that. What do they want you to do, possibly? Having said that, let me move to another argument. The question is, what is the status quo? And before I go to that, my lord, allow me to finish that point of joinder. Let me just finish that point of joinder before I go to that point.
Yes.
What is the prejudice that the respondent in this matter has possibly suffered by joinder of the Speaker? We submit none. For example, the replying affidavit to the application for conservatory orders and to the main petition was prepared and sworn by Mr. Jeremiah Nyegenye, clerk of the Senate. Meaning, the respondent clearly understood that he was sued on behalf of the Senate, and that's why he chose a competent officer of the Senate to prepare the affidavit and file it. I want to finish that point by saying that that repeated argument has no justicial priorities.
Yes.
I had made out an argument now that of August 2021, the Senate passed a resolution to remove the governor of Meru from office by impeachment.
Yes.
It is also true that under Article number 23, Clause 3, Paragraph C of the Constitution, this court has constitutional power to issue a conservatory order. And therefore, these two powers were exercised. Parliament exercised its power under Article 181. Court exercised its power on 21st of August 2024 under Article 23(3)(c). The proper question then is this: these two powers having been exercised by these constitutional institutions, what is the status quo? And the answer becomes, the status quo pursuant to the conservatory order issued by this court is what we call the status quo ante, the status quo preceding that action of the Senate. So what is that status quo? Honorable Kawira Mwangaza was and remains the governor of Meru County. It has been alleged that there was material non-disclosure, or that this court was misled in making the conservatory order of 21st of August. First, my lord, you know, in my other word, I'm a teacher. And I get disturbed a little when things are made that disturb my intellect.
Yes.
The order from the High Court in Meru was produced and attached to the petitioner's affidavit as Annexure KM3. It was produced and given to you.
Yes.
There is a strong presumption that you read that order yourself, given to you, and issued an order. How can the petitioner, who has presented the full ruling of the court, be accused of material non-disclosure? I kept telling my colleague, Mr. Mutuma, I need new schooling on non-disclosure. There can be no better disclosure than actually presenting the physical copy of the ruling for the court to read by itself. Let me then get to the second limb of this argument. The court in Meru began by framing the issue before it. Then it gave an order. Let's see the issue as framed and the order as given. When you look at Annexure KM3, at paragraph 1, the court said, this court I hope my few minutes are frozen.
Yes.
Thank you so much.
This is begins at page 9.
Correct.
Yes, I'm there.
That ruling. If you can paragraph, it says, this court has to make a decision as to whether to grant interim orders or preserve a status quo or not. So the issue before the court is not limited to a particular motion. The issue is whether to preserve a status quo or not. Then, if you got now page 12, which is now page 4 of the ruling.
Yes.
Page 4 of the ruling, the court then makes the order. The upshot of the above is that the impeachment process is halted, not the impeachment motion. The impeachment process is halted. The court is saying, I'm halting the process to preserve the status quo. How can my colleagues say that this was not an order before this court? While at it, if you look at the supplementary affidavit of the governor, both at paragraph 8 of that affidavit and annexure BKM2 to that supplementary affidavit,
yes.
the moment the county assembly approved the impeachment motion, learned counsel for the governor, Mr. Mutuma, wrote to the Speaker of the Senate, drawing the Speaker's attention to this court order.
Yes.
The letter you'll see on the face of it is stamped by the Speaker, who is the respondent, and stamped by the clerk, who is the deponent of the affidavit of the respondent.
Yes.
My lord, how can my learned colleague make an argument that the Speaker was not a party to that suit? Doesn't the Speaker of the National Assembly have an obligation under my apologies, the Speaker of the Senate, yes, have an obligation under Articles 10 of the Constitution to uphold the national value of the rule of law by virtue of his office? How can a Speaker who knows of a court order, as was done in this case, and continues to allow debate in violation of that court order, come and claim I was not a party to those proceedings? I mean, that is bad governance in a class of its own. It is good governance topsy-turvy. It should not have been done in the Senate. It was done. It should not have been done in this court by officers of this court. They must join us in frowning upon this conduct of these two officers, because our own oath of office as advocates gives us obligations beyond our clients, which is the obligation to uphold the rule of law. So, my lord, you will see at a second level the response by the government. In response to the motion at the Senate, she made that claim that they are pending court orders. You will see the debate by Senator Halwale in the proceedings of the Senate. He asked the Speaker to consider that all those things are in the affidavit in support of the main petition. And therefore, anyone to argue there was no court order, that is not being very candid with this court. And that should be,
for the completeness of my record.
Yes.
The ruling, let's bring it back up. The ruling dated 24th July 2024 by my brother Kassan J.
Yes.
It concludes,
yes.
This is page 12 of your bundle.
Yes.
The upshot of the above is that the impeachment process is halted.
Yes.
Pending my ruling.
Yes.
And since this is a matter of public interest,
yes.
the rulings into brackets,
yes.
PO, interested parties and main petition will
yes.
be delivered on Monday, the 29th day of July 2024.
Yes.
By email to all parties.
Yes.
Was this ruling delivered?
No, it wasn't delivered. In fact, the judge recused himself from the matter before the ruling was delivered, and the ruling was subsequently delivered by your brother Justice Murithi long after this impeachment process, dismissing the PO.
Yes. Ruling.
Yes, sir. No. Just check the page after that ruling. Is there an order of court dated 29th July?
An amended order.
Yes, that one. That's what transpired on the 29th. Whatever you see there is what transpired on the 29th. Yes.
J dismissing the PO.
Yes. And you'll notice that the ruling was deferred to 20th August by Order 5.
Mr. Ngoya, is that ruling dismissing the PO, is it before me?
No, it is not. It happened quite recently. Long after this petition was filed. I'm just trying to remember the date. It's a much subsequent development, long after we filed this petition, this application. I just answered it because my lord, you raised it.
Mr. McKenna, would you have an objection to the petitioner filing that ruling so that I can see it? In reality, I can obtain it, but that is not the proper way of doing it. It should be placed properly because there's been a lot of reference to that process and what it is. Should we have that ruling before this court?
I will not object to that. I mean, not
correct.
Just
yes,
no problem.
No arguments.
No arguments. Yes.
You don't even need to put it in an affidavit.
Yes.
You just file it in CTS.
Correct.
And you serve your counterparts electronically.
Correct.
Don't worry, your time had been
frozen.
Frozen?
Yes. Allow me just to submit on the question of prejudice, because that again has been raised. And if you look at the Munya decision, which is, I think, to my mind, the locus classicus on the question of conservatory orders.
Yes.
The Supreme Court gives us guidelines on granting conservatory orders. We must look at the impact the decision beyond the petitioner. That's essentially what the Supreme Court is telling us.
Yes.
And let's just try to reflect on this, the legal consequences of not preserving this conservative order. Article 179, clause 9.
Yes.
Article 179, clause 7 of the Constitution says, if a vacancy arises in the office of the county governor, the members of the county executive committee appointed under clause 2B cease to hold office. So this is a legal consequence. When my colleagues say they can continue, how? They don't say they must stop holding office. Let's try to think about the public interest on this, my lord. It will mean
Yes.
the deputy governor once sworn in then must appoint new CECs, because those others stopped holding office by operation of law. It's not a discretion on the part of the governor. Hiring those new CECs means, my lord, taking them through the vetting process at the taxpayer's expense, the approval process at the taxpayer's expense.
Yes.
It means replacing now the deputy governor, because the deputy governor has assumed the office of governor. It means replacing a deputy governor now at the taxpayer's expense. When my colleague keeps saying the governor can be compensated, who will compensate these taxpayers? This is irreparable damage, my lord. I've never seen more irreparable damage than that.
Yes.
They will come into office, they will be entitled to the usual things, medical cover, their mortgages and grants, if any, provided by SRC. These are all consequences. So that if you eventually return the governor to office, it also follows that that deputy governor who assumed the office of the governor has vacated office, those CECs also vacate office. The governor again begins another process of hiring CECs and other senior bureaucrats.
Just a moment.
I'm just looking at the legal consequences only.
Just a moment.
Yes, I appreciate.
So if these conservatory orders were lifted,
Yes,
and then the petition succeeds,
yes,
there would be need in the orders for the CEC members
Yes.
who have come in
yes,
to be removed,
correct,
the new DG
yes,
to be removed,
correct,
and the status quo ante
Correct.
to be re-established.
Correct.
That is your submission.
That's my submission. And I'm just saying by operation of law. There's no discretion. Because my colleagues kept saying that who said he must remove the CEC. The law itself says once this one leaves office, those CECs leave office. They can only come back to office by reappointment. And my lord, when you begin reappointing, it's a fresh appointment. It's like the other day, my lord, when the president removed CSS from office, and now I'm just giving an example. I'm giving a matter in the notorious. Apologies. Okay, I'll leave it at that. But I'm saying by operation of law, Article 179(7), they must go. Then get appointed or fresh ones appointed by the DG who assumes the governor. Then assume the petition succeeds. Those ones whom the DG had appointed must also go by operation of law, Article 179(7). Then the governor returns to office and begins another appointment process. I'm making a simple argument, my lord. This is overwhelming expense to an already burdened taxpayer in Meru, like all of us.
Yes.
Compare that, my lord, to a matter that is within our control completely, where we can break our backs in this court and say in the next 1 month, in the next 2 months, we must finish hearing this petition so that the chips fall into their place. This is a very proportionate way of use of power. We finish these matters, the chips fall in their place. If the governor is going, as the young people selling in the streets, anaenda akiendanga. She has lost, she now goes completely. If she's remaining, she remains. That is more within our control. It saves the taxpayer, the public significantly. I urge,
5 minutes.
thank you so much. I want to rest at that and invite my learned colleague, Mr. Mutuma, to then use the 5 minutes to make the argument I wanted to make. And thank you so much for the audience, and a good afternoon, my lord.
Mr. Mutuma?
Yes, thank you, my lord. I'll just buttress one issue on whether the governor is capable of being compensated by way of cost.
Yes.
My lord, assuming that that was a possibility, that cost would be paid by the respondent, the Senate, the Speaker of the Senate,
Yes.
using taxpayers' money. So it would still be against public interest to compensate the governor using taxpayers' money. That cannot be an option, my lord.
Yes.
Two issues, my lord. One is still on the issue of prejudice. You would have expected, my lord, just like I did, that the respondent and the third interested party would demonstrate the kind of prejudice they would suffer if conservatory orders remain in force.
Yes.
I must state, my lord, that none of them has even alleged the kind of violation or prejudice that they would suffer should the conservatory orders remain in force.
Yes.
The Speaker of Senate, being a neutral arbiter in the matter and having discharged his mandate,
Yes.
no longer has any prejudice to suffer, whether the conservative orders remain in place or not.
Yes.
There is no injury on the Speaker or the Senate. They have not even alleged that they have any prejudice.
Yes.
On the part of the third interested party, he appeared in court wearing the public interest hat,
Yes.
and we all agree, my lord, that public interest is a key consideration in this matter, in granting or denying conservatory orders.
Yes.
The question that we are not agreeing on is where does that public interest lie?
Yes.
The governor before you was popularly elected by the people of Meru. There has been only one voter who has come before you to allege that they are unhappy with the conservatory orders. No other voter.
Perhaps in rejoinder,
Yes.
you shouldn't go down that road, because they have not filed an affidavit. I do have a pending number, I think 2 applications for joinder. Perhaps we can just limit it.
Thank you, Madam. So my submission in respect to that issue is that the third interested party ought to have demonstrated by way of an affidavit the kind of prejudice they will suffer if conservatory orders remain in place. They have failed to do that.
So your lordship,
Yes.
that would not be fair to us.
No. You don't address Mr. Mutuma, Mr. Kidini. You've been in practice for very long.
Indeed.
You address me.
So your lordship, with all due respect, I think it would not be fair to the third interested party on that submission that we did not file evidence. And whereas the court directions were clear that when it comes to value of submissions, it's not out of wish that we notify. Let him limit himself to the issue of the law.
So Mr. Kirimi and Mr. Mutuma, I think that may not be a large issue. My recollection is that this was by consent, and the parties agreed that the fastest way to move to this day would be by the interested parties being limited to filing on the submissions. That is why, Mr. Mutuma, when you began that route, I tried to navigate you back. So
thank you, my lord. On the last issue, is that you will note
yes,
from the response by the respondent in this matter,
yes,
they have not bothered to in any way controvert the allegation that the proceedings at the Senate were marred by violence, chaos, and disorder, making it impossible for a fair trial to take place.
proceedings of the Senate were marred by
Violence, chaos, and disorder, making it practically impossible for a fair hearing to take place. They are the custodians of proceedings at the Senate. They have not denied that indeed there were chaos. My lord, we invite you to look at paragraph 58 all the way to paragraph 60 of the supplementary affidavit. We have taken time to extract verbatim
paragraphs
58 all the way to 60 of the petitioner's supplementary affidavit.
Sorry, that is your time, but I'll give you a little bit
Yes,
more.
I'm concluding.
58 to 60?
Of the supplementary affidavit,
Yes.
we have taken time to produce verbatim extracts of what transpired at the Senate. Specifically, paragraph 58 attaches the Hansards that confirms indeed the Senate became ungovernable with the Speaker of the Senate doing nothing to bring the House to order.
Yes.
The petitioner was doing a joint declaration on the submission. They won't have a chance to respond to some of the issues that take place, both chaos in the house and such.
Well, these are matters that we must oblige.
Now, counsel, it is not for this court to direct, but what I recorded, you say, just a moment, I've written quite a lot, I have to find exactly where I recorded you. The proceedings at the Senate were constitutional and regular. Now, if you say that in your highlighting aspect, then the petitioners, counsel in rejoinder, have some latitude to point out to why they think they are not constitutional and regular. But I do take your point, so counsel, don't stray too far.
I'm actually concluding, my lord. The point I'm making before I sit down is that the proceedings cannot have been said to have been regular. The proceedings could not have afforded the petitioner the right to fair hearing as envisaged under Article 50 of the Constitution.
Yes.
In light of the violence, chaos, and disorder.
Yes.
We fault the Speaker for failing to bring the House to order, to generate a conducive environment for a fair hearing to take place. That fact having not been controverted,
Yes.
it remains an issue that can be comfortably said to have been admitted. On that basis, my lord, it is our humble submissions that the applicant in this matter has met the threshold and criteria for issuance of conservatory orders. The balance of convenience tilts in a favor. Public interest is in favor of granting conservatory orders, and there would be absolutely no prejudice on the part of the respondents or indeed any other party if conservatory orders are maintained. On the contrary, the damage would be irreparable both to the petitioner and the public should the conservatory orders herein be discharged. On that basis, my lord, we wish to rest our case and wish you a good afternoon.
So that marks the close of highlighting of written submissions on both the application for the conservatory orders as well as the counter application by the respondent. Ordinarily, I would be proceeding to issue yourselves a ruling date on both applications. I am not able to do that today. I think, Councillor Ngoya, you noted you had not paginated.
Yes.
May
I remedy that right away? I've paginate, so I can withdraw that and give you a paginated version. So that I just remedy right away.
We will do that administratively with our Mr. Guyo. The other issue is on your submissions. Mr. Guyo will engage with yourselves. He'll give you my court email address so that I can have your submissions in Word, not the annexures, just the text of it. We can have a mention, because I don't want to take us too far. Mr. Guyo? It's just to confirm compliance and to take a ruling date. Now, Thursday is a public holiday. I know it is likely that persons will have traveled. Can we say Tuesday next week? Any objection? It will be virtually. 15th October, any objection? Now my fingers have been burnt when I've done that, where when I retire I find there's been no compliance and then I have to issue a date calling for my previous date. 15th is not too far away. So make sure everyone has filed everything. I also encourage you, because I've not gone through every page of every volume. Mr. Guyo, help me with volume 6. So this is volume 6 of annexures. It runs to page 3742. I encourage all parties to ensure that what you've uploaded into CTS is legible. I can clearly read it. So just go in and confirm. And also you can help me, you can assist me greatly by giving me hard copies. So we'll be coming on Tuesday to confirm that, so that I have hard copies that I then use for a ruling. Now, Mr. Kirimi, I hear you. Let me assure you that between myself and my able Mr. Guyo, we already have a date, and that is the date we will be informing you on Tuesday next week. So, Council, thank you very much for your
patience and your very, very good submissions. Let's meet on Tuesday.